न्यायपालिका के इतिहास में शायद ही कभी इतना विवाद किसी भावी चीफ जस्टिस ऑफ इंडिया को लेकर हुआ हो जितना अब जस्टिस सूर्यकांत को लेकर हो रहा है। प्रधानमंत्री नरेंद्र मोदी को भेजे गए एक विस्तृत पत्र में सुप्रीम कोर्ट के पूर्व बार एसोसिएशन सचिव अशोक अरोड़ा और वित्तीय कार्यकर्ता अरुण कुमार अग्रवाल ने यह मांग की है कि जस्टिस सूर्यकांत के खिलाफ लगे भ्रष्टाचार, संपत्ति की हेराफेरी और एनडीपीएस मामलों में रिश्वत लेकर जमानत देने के आरोपों की सीबीआई या एसआईटी जांच कराई जाए, इससे पहले कि उन्हें भारत का अगला मुख्य न्यायाधीश सीजेआई नियुक्त किया जाए। इन आरोपों को कोई मामूली व्यक्ति नहीं बल्कि सुप्रीम कोर्ट के ही जज जस्टिस आदर्श कुमार गोयल ने अपनी गोपनीय चिट्ठियों 2017 और 2018 में दर्ज किया था। उन्होंने साफ कहा था कि बिना स्वतंत्र जांच के जस्टिस सूर्यकांत को किसी उच्च पद पर नियुक्त करना उचित नहीं होगा। पत्र में कहा गया है कि जस्टिस सूर्यकांत की कई संपत्तियां वास्तविक कीमत से 7.63 करोड़ रुपए तक कम दिखाकर खरीदी बेची गईं, जिनमें दिल्ली के ग्रेटर कैलाश, चंडीगढ़ सेक्टर 18 और पंचकूला की प्रॉपर्टियां शामिल है। इसके अलावा एक बेनामी ऑर्चर्ड 18 करोड़ रुपए की भी बात कही गई है। अब नई तस्वीर ने बढ़ाई आग। इसी बीच एक तस्वीर सोशल मीडिया और अखबारों में वायरल हुई जिसमें जस्टिस सूर्यकांत हरियाणा के मुख्यमंत्री नायब सिंह सैनी के साथ एक विशेष रात्रि भोज स्पेशल डिनर मीटिंग में दिखे। बताया गया कि वे इस डिनर में कई अन्य जजों के साथ शामिल हुए थे और मुख्यमंत्री के साथ तस्वीरें भी खिंचवाईं। न्यायिक आचार संहिता जुडिशल प्रोटोकॉल के अनुसार किसी भी जज को राजनीतिक व्यक्तियों के निजी या सामाजिक कार्यक्रमों में शिरकत करने की अनुमति नहीं होती, क्योंकि इससे न्यायिक निष्पक्षता पर सवाल उठता है। लोगों की यादें ताजा हुईं। याद कीजिए जब सीजेआई डीवाई चंद्रचूड़ के घर प्रधानमंत्री मोदी गणपति पूजा में गए थे तो किस तरह जज सरकार की नजदीकी पर बहस छिड़ी थी। अब वही बहस फिर लौट आई है, इस बार जस्टिस सूर्यकांत को लेकर, जिनकी सिफारिश वर्तमान सीजेआई बीआर गवई ने कर दी है। सबसे बड़ा सवाल, क्या भारत को एक दागदार चीफ जस्टिस मिलने जा रहा है? क्या इन गंभीर आरोपों जो खुद सुप्रीम कोर्ट के जज ने प्रधानमंत्री को लिखे पत्र में दर्ज किए हैं को नजरअंदाज कर दिया जाएगा? पत्र की मांग। प्रधानमंत्री मोदी से मांग की गई है कि आईबी और सीबीआई से रिपोर्ट मंगाई जाए। 2018 और 2019 की कॉलेजियम बैठकों के रिकॉर्ड सार्वजनिक किए जाएं और तब तक जस्टिस सूर्यकांत की नियुक्ति पर रोक लगाई जाए जब तक कि सभी आरोपों की निष्पक्ष जांच न हो जाए। न्यायपालिका की स्वतंत्रता कागजी नहीं होती, वह जनता के विश्वास से चलती है। और अगर जनता को यह लगने लगे कि जिस पर आरोप है वही न्याय का रखवाला है, तो फिर यह सवाल अनसुना नहीं रहेगा, क्या भारत को एक भ्रष्ट मुख्य न्यायाधीश मिलने जा रहा है?
Mr. Rakesh Khanna, Senior Advocate, President of the Supreme Court Bar Association. Respected Meenakshi ji, Senior Advocate. Shri Sharma, Senior Advocate, Vice President of the Bar Association. Other office bearers of the Supreme Court Bar Association, Senior Advocates and members of the Bar. I am thankful to the Supreme Court Bar Association for giving this opportunity to exchange the ideas on a subject which is very close to our hearts. Whether the lawyers or judges, we all are concerned about the access to justice. What was begun with by Shri Khanna, Meenakshi ji concluded with a very deep insight of the constitution and judgment of this court, explaining the very concept of access to justice, what are its ingredients, and what is required to be done to achieve this loud goal. The question of wanted infrastructure, the question of requisite strength of the judges to meet with the judge litigation ratio, The question of geographical distance, which has become a stronger factor to dissuade the litigant to come and approach the judicial forms, and several other issues which have been really identified as the barriers for the access to justice, have been very well explained by Meenakshi ji. Therefore, I need not to repeat all those issues. As you know it, the Roman saying that whenever there is a wrong, there has to be a remedy, is the foundation basis when the concept of access to justice started developing. 1948 Human Rights, International Human Rights Declaration, and eventually followed by our own constitution through Article 39A. Several legislations, Legal Service Authorities Act, Constitution of Nalsa, State Legal Service Authorities, and going up to taluka level, appointments of, very briefly I am pointing out, even the paralegal volunteers and what not and what else. All these efforts have been made to achieve this goal of access to justice. I had a special privilege to work for 2 consecutive terms as a member of the Managing Committee of NALSA from 2007 to 2011, and you will find that most of the schemes formulated by NALSA are notified in 2010. I did contribute in formation of those schemes, but I am not on that academic concept of the access to justice. The last point which Meenakshi ji raised before you, the most pertinent point, that where and how are we going wrong in translating this concept into reality? Where are we lacking in practical terms that the concept of access to justice is still being discussed in workshops, seminars, lectures, in auditoriums? Why it has not reached to the general masses? And what are those actual barriers and how to deal with that? She very aptly pointed out and made a appeal to all of you that the lawyers need to come out, pro bono services, even young lawyers who can be funded from different sources, and they can provide a kind of paid but free legal aid to the set of litigants who, because of the economic constraints, are unable to approach the legal forms. There is no doubt about it that free legal aid, accessible justice system, and equality in terms of no difference between poor or rich, workman or industrialist, employer or employee, all these are fundamental to the concept of access to justice. But then my personal viewpoint is that we are lacking in commitment. And unless you are committed to a cause, regardless of the best of the infrastructure which is made available, regardless of all other requirements are taken care, funds provided, you may not be able to achieve the desired result. On illustrative basis, I will just give you one example. I have been also the executive chairman of the State Legal Service Authority, and it was not that Legal Service Authority alone as an exception. I am talking all India basis, pan India. there are more than adequate funds being provided by the central government to legal service authorities for the purpose of engaging good quality advocates, pay them a reasonable amount of fee, where only NALSA has prescribed the minimum one, and ensure that the trust and faith of the litigant who is not in a position to afford legal services of the private lawyer, that is restored and built up, and they are also attracted to engage the legal services, legal aid, the advocate of their choice through the platform of legal services. And practically and factually what's happening is that many legal service authorities are unable to utilize the fund, and there is an annual return. The amount is returned to the state governments or the central government or the other agencies from where it comes, all government agencies only. My personal very strong view is that the concept of access to justice, legal aid, legal services cannot be implemented mechanically through rule books or through prescription. It has to be imbibed in the mindset, and there has to be a commitment by individuals forming a group and then take it and lead it as a movement. Access to justice actually is a very innovative idea. Where, how, in what circumstances, and what type of access to justice you need has to be invented and seen and implemented, translated then and there. There are situations where as a advocate, as a counsel for the party, or as a judge, if you start perceiving yourself to be bound down by the rule book, and if you continue to involve yourself in the adjudicatory process, keeping in view in mind the litigant who is before you, or the brief or the file which is before a judge, mind you, it may lead to gross violation of access to justice, may not be to that litigant, but to thousands or hundreds or so many other individuals. That's why in one of the conference of Commonwealth Judicial Education platforms, I raised an issue. Fortunately, all big stakeholders from different Commonwealth jurisdictions were present. Indian judges were also there. Justice Madan Lokur, as a sitting judge of the Supreme Court, was there. Professor Madhav Menon was alive and he was there. I raised an issue that have we ever thought of protecting the right of an invisible litigant?
और आप हमसे जुड़े रहने के लिए सब्सक्राइब करें YouTube पर, फॉलो करें Twitter पर और लाइक करें Facebook पर। और ज्यादा जानकारी के लिए आपको टाइप करना होगा सिर्फ न्यूज़ नशा।